Are you a beneficiary of an estate with assets in Spain? Are you aware of any conflict regarding the inheritance you may be the beneficiary? Are you appointed as an executor of a will in Spain? You may have some experience of someone who has died in your own country, or maybe you've been appointed as an executor before, or maybe you've been also a heir, a beneficiary of an inheritance. Whether you have experience or not, you know that the inheritance process may be complex, may be time-consuming, and also expensive, especially related in Spain, according to international law and also to international inheritance tax. I am going to explain you if you are a beneficiary of an Spanish estate, how to calculate the inheritance tax, and which documents are needed in an inheritance. First of all, how to know if you're a beneficiary. It is important to set down who will get the assets. It is extremely crucial. And in this situation, we have two different scenarios. The first scenario, if there is a will, it is chosen who are the beneficiaries, what will be get by each beneficiary and how it's going to be get. And the other scenario is where there is no will. There is no will, has not been made a will, so we need to enter in applicable law between a conflict of law between national law or residence law. This is why we extremely recommend to make a will, because under Spanish law there are limitations, which is no freedom, so hardship rules will apply. Why it is important to make a will? It is important to set down who is going to be the beneficiary, what that person is going to receive, and how it's going to be received. I need to introduce you briefly the regulation 650-2012 regarding jurisdiction, applicable law, and enforcement in regards of matters of succession. It's extremely important, these two articles, Article 21 and Article 22 of this European Law Act. Article 21 says, will govern the law of the state in which the deceased had his habitual residence at the time of death. So it means that if someone is living in Spain as a resident, Spanish law will be applied. But we have an exception, which is Article 22, which is the choice of law. So a person may choose as the law to govern his succession as a whole. So the law of the state whose nationality he possesses, which means that someone directly, expressly says, mentions which is the applicable law on his succession, in his will, and that law will be applied. Let's put an example in order to clarify this situation. A British couple from Southampton, they came to Spain 10 years ago. They own a property, they own a car, and a bank account. Both of them, both spouses, they made a will, a mirror will. So he left everything to his wife, and she left everything to her husband, with a substitution their children. If there is a will, they should have said or mentioned, strictly says in the will, that the British law will govern to his will. And that will happen. This is what will happen. In case there is no will, we go to Article 21, as we said before, and the applicable law will be the habitual residence of the deceased, which is Spain. And under Spanish law, the descendants will get 2/3 directly. One of the important questions and worries is regards inheritance tax. Let's go through the same example, as I said before. This British couple from Southampton that they came 10 years ago to Spain, they own a property jointly, 50% each one. They also owned a bank account, also jointly, 50% each one. And one of them owns a car. In total, including the furnishing, which is 3% that we need to add to the value to be received by the heirs, we have a value of 146,775 euros in this example. Taxes to be paid according to this base we need to mention two important things. First thing, tax allowance to family members, which in Spain, and especially in this area, in Comunidad Valenciana, where we are, with family members is deducted 100,000 euros to the base to be taxed. But also we have a deduction of 95% of the value of a property, which has some limits, needs to be kept or not sold in the following 5 years. On this example, which is a very typical example, will not be tax to be paid. But even though if it should be paid some tax, with a different example, for example, someone who has some life insurance, some bonds, some ISA outside Spain or in Spain, and may have to be paid some inheritance tax, then will be reduced again 50% on the quota to be paid. So it is extremely important to instruct an international tax advisor in order to check perfectly which is the tax to be paid in Spain, but also to check which is the international double taxation treaty between Spain and the country where the assets are. Lastly, I will mention which are the documents needed on an inheritance. On this picture, you can read a list of the main documents that we apply in order to start an inheritance process. It is extremely important that the public documents are apostilled through the Hague Convention from 1961 or legalized, as well as they need to be duly translated by a sworn translator. As you can see, the inheritance process may be complex and also time-consuming. So this is why it's extremely important to instruct an expert, a cross-border succession lawyer, in order to manage and defend you on the international basis, on the applicable law and also on the inheritance tax. I hope that I have helped you in order to understand the inheritance on an international basis in Spain. Thank you.